Right, we're beginning chapter 8, selling real property. We're going to talk about the purchase contract and some legal issues that can arise with the purchase contract. So there was already another video where we took a look at what a purchase contract looks like and what types of provisions are typically in a purchase contract. Well, one of the issues that can arise is if that contract is not in writing. As a general rule, any oral agreement for the sale of an interest in real property has to be in writing. If it is just an oral agreement for sale, then it's not enforceable. And the rule that says that it's not enforceable is called the Statute of Frauds, and it's a very old rule. It holds that for a contract, for the sale of any interest in real property to be enforceable, it must be written, but also it must contain essential terms and have a signature. So it must be written, it must contain essential terms, and it must have a signature. So what are essential terms? Well, essential terms are, they can vary state by state, but typically what you see is the identity of the parties, the price, and the property description. So if you have the name and the identity of the parties, the price, and the property description in writing, then you have met the essential terms element of the Statute of Frauds. So the requirement that an oral agreement be written down doesn't mean that it has to be written in a formal contract. It can be an informal memorandum that would suffice for the writing element. So for the writing element, all you need is an actual writing with the essential terms. For the third element, the signature, the writing must be signed by the party that is going to be bound by the agreement. So if it has to do with the sale of land and the seller is going to sell their property to the buyer, for the seller to be bound, they have to have signed this contract. Now, very important note that just because there's an oral agreement that violates the Statute of Frauds, it doesn't mean that the agreement is void. It just means that it's not enforceable in a court of law. So if one of the parties breaches, then it wouldn't be enforceable. So does that mean that all oral contracts, oral agreements to transfer real property are unenforceable? What happens if the transfer of land is not in writing, right? Well, there are two doctrines that provide exceptions to the Statute of Frauds. The first is that of part performance, and the second is equitable estoppel. The doctrine of part performance says that an oral contract for the sale of real property may be enforced if the buyer, 1, takes possession, 2, pays at least part of the purchase price, and 3, makes improvements to the property. Now, your book does note that some jurisdictions don't require that all of these three elements be present. For our purposes, just to simplify things, we're going to require that these three elements be present for the purposes of the exam. Okay, so you're going to look for these three elements. Well, let's say you don't have these elements. And is there another doctrine you can use? Yes, it's called equitable estoppel. It says that an oral contract may be enforced if one party acts to his detriment in reasonable reliance on another's oral promise, and there is serious injury that would result if enforcement is refused. So the common fact patterns that you'll see with equitable estoppel is perhaps a buyer, in reliance on the seller's promise, sells the house that they currently live in. And so that would be detrimental reliance, right? They would then have to show that serious injury would result from them not being able to purchase the property from the seller, right? Okay, so in the next case we're going to look at, we'll see how both part performance and equitable estoppel are used with the fact pattern to see how they're applied. The case is Hickey v. Green. So Hickey v. Green, the facts are as follows. Green owned Lot S, and this lot was a vacant lot in a residential neighborhood in Massachusetts, and she advertised it for sale. On July 12th of 1980, Green and Hickey's orally agreed that Green would sell the property to Hickey. So Green accepted a deposit check from Hickey. And on that deposit check, Hickey had written on the back of the check, quote, deposit on lot, Massiot Avenue, Manomet, subject to variance from town of Plymouth. Now, Green was unsure or Green's brother and Green's agent were unsure as to whether or not the Lot S could need, whether or not it needed some variance from zoning in order to build it as a residential property. And Mr. Hickey was unsure of whether Green or Green's brother wanted the check to be made out to them. So he left, they left the pay to section on the check empty. So Green held the check. She accepted it from Hickey, but she did not fill the payee's name in it, nor did Green cash or endorse it. And relying on this acceptance of the check, the Hickeys then advertised their own home for sale. And they entered into an oral agreement to sell their house. They took a $500 deposit from a buyer for their house, and they deposited that check into their bank account. Well, on July 24th, 2 weeks later, Green told Hickey that she had changed her mind, and she decided to sell Lot S to someone else for $16,000 instead. So Hickey told Green that he and his wife had already sold their house, that they had accepted an offer for the sale, and so he offered to match the $16,000 offer, but Green refused. So Hickey filed a complaint seeking specific performance, and the trial judge granted Hickey's request. Then the Massachusetts Appeals Court affirmed but remanded the case so the trial court could look at the facts and amend the specific performance judgment if it was appropriate. The court applies both the equitable estoppel and part performance exceptions to the facts of the case. They found that there was no doubt that Mrs. Green made a promise to the Hickeys, and the Hickeys relied on that promise, and she repudiated the promise because she had a better opportunity. And the court felt like in equity, they needed to rule on behalf of the Hickeys. So they remanded to the trial judge for the purpose of amending the judgment to require the conveyance of the lot by Mrs. Green. But, of course, they also required that the Hickeys needed to pay the $15,000 price agreed. Now, what's further interesting about this case is there was actually a writing. Technically, what was written on the check could be considered a writing. However, it was missing a key component that it needed in order to comply with the statute of frauds. And that component was that it needed to be signed again by the person who was trying to be held accountable, and that would have been Mrs. Green. And she didn't sign the check, right? So in these circumstances, had Green wanted to sue Hickey in order to have them perform on the contract, she would have been able to do that because Hickey signed the check and the check had the material terms. But because Hickey is suing Green and Green did not sign the agreement or the check in this case, they could not rely on that argument in this case. In the next video, we're going to take a look at marketable title, another issue that can arise during the sale of property.